All right. Thank you, everybody. We'll get things in order, and I'd like to welcome everyone to the Standing Committee on Economic Development and Environment. I want to thank everyone for being here this evening. The committee is obviously very pleased to have this time to hear from Minister Moses and, of course, the Workers' Safety and Compensation Commission on Bill 25. We're also looking forward to hearing from any members of the public, and we know we have at least one here this evening who may wish to speak to the bill. If you would like to share your views with the committee today, please let the clerk know, and he will make sure to add you to the list. That's Mr. Michael Ball to my right. And we're also willing, of course, to accept any written submissions. Let me begin by asking all members for the record to introduce themselves, and I'll start on my far left.
Good evening, everyone. Welcome, Herb Nakamak from the Nukput.
Good evening, Kieran Tester, member for Cam Lake.
Danny McNeely, Satu.
Kevin O'Reilly, Frame Lake. RJ Simpson, Hay River North.
And my name is Corey Van Thyn, MLA for Yellowknife North, and I am the chair of the Standing Committee on Economic Development and Environment. We also have with us today from the Law Clerk's Office, Mr. Glenn Rutland, from the Research Office, Ms. Kathleen Kanuch, from the Clerk's Office, Mr. Michael Ball. I'd like to remind members and witnesses that our proceedings today are being recorded for rebroadcast of the Legislative Assembly's television network. Today, this committee is holding a public hearing on Bill 25, an act to amend the Workers' Compensation Act. This bill is currently under the committee's review. Copies of Bill 25 are available on the side table at the end of the room. I would like to talk a little bit about the legislative process for reviewing bills, so those of you who are joining us this evening can better understand the process we are following. After a bill receives second reading in the Assembly, it is referred to a standing committee for review. At that time, it also becomes a public document. The role of the committee is to consider the bill in detail or clause by clause. The committee does that in various ways. We review the bill with our research and legal staff, who provide us with additional information and clarification to help with our consideration. We can invite stakeholders to provide us with their thoughts on the bill and ask the public for its views. We hold hearings to give the public a chance to comment. Our job is to hear what everyone has to say, to ask questions, and to make sure we understand the details of the legislation and the concerns expressed by the public. When we think it is warranted, we may propose changes to the bill. I would like to take this opportunity to point out the unique nature of Bill 25, the shared nature of the Workers' Safety and Compensation Commission, WSCC, between two jurisdictions, the Northwest Territories and Nunavut, gives rise to a unique situation. Two distinct and sovereign legislatures are concurrently considering amendments to two pieces of mirrored legislation to govern a single body that conducts business in both jurisdictions. This means that at the same time that we are considering Bill 25, our counterpart in Nunavut, the Legislative Assembly of Nunavut's Standing Committee on Legislation, will be considering Bill 8, which largely mirrors the provisions of Bill 25. While the circumstances that have given rise to two different legislatures in two independently governed jurisdictions considering mirrored legislation are unusual, they are not without precedent. The most recent times this situation occurred was in 2018, when both Nunavut and the Northwest Territories considered establishing the Chartered Professional Accountants Act, and prior to it in 2015, when both territories considered review of the Northern Employee Benefit Services Pension Plan Act. It was 2007 when both Nunavut and the Northwest Territories considered a new Workers' Compensation Act. Passage of this act allowed both jurisdictions to continue to share a single Workers' Safety and Compensation Commission. Now I'll turn the floor over to Minister Alfred Moses to introduce his staff for the record and to make his opening remarks. Minister Moses.
Thank you, Mr. Chair, and thank you to members. I know it's been a long day, and appreciate the time and commitment to come to the meeting this afternoon or this evening. I am pleased to be here today to present Bill 25, an act to amend the Workers' Compensation Act, and I appreciate the chair giving a little bit more clarity on Nunavut side of things and Bill 8 and the work that's going on there. I do believe they've gone through their second reading on October 25th, and that's something we'll be closely monitoring as well. With me today, I have on my immediate left, Ms. Kim Collins-Riffle, sorry, Vice President, Stakeholder Services and Acting President of the Workers' Safety and Compensation Commission. On my far left, Ms. Marcelle Marion, General Counsel of the Workers' Safety and Compensation Commission. Joining us today as well is my Ministerial Special Advisor, Ms. Rana Sherigan, and Elise Scott, the Chief Governance Officer and Senior Administrator of the Workers' Safety and Compensation Commission. Mr. Chair, this bill amends the Workers' Compensation Act to do the following: clarify the usage of terms impairment and disability, add detail respecting who is considered an employer within the scope of the Act, remove the requirement for a primary health care provider, clarify the compensation paid to dependent children of a deceased worker and also maintenance enforcement garnishment, add EI benefits as a category of remuneration, authorize information sharing and disclosure for the purpose of improving the administration of the Act, enable an inspector to inspect healthcare providers' records to verify service received by injured workers, and correct inconsistencies and errors identified in the Act. The reason for the amendments in Bill 25 are to ensure certain provisions are in compliance with court decisions, improve operational efficiencies in the WSCC, and clarify language for clear information and interpretation. Mr. Chair, this concludes my opening remarks, and I do look forward to answering any questions that committee may have. Thank you, Mr. Chair.
Thank you, Minister. And just a reminder before we get started, for those who are not familiar, we exchanged the conversation through the chair. There will be no need for you to touch your microphones. Our technician can do all that when you do the exchange of conversation through the chair. And I will be turning it over to committee for questions. And Minister, if you just indicate either by letting me know by pointing or what have you, or one of you simply raising your hand slightly, and then I'll know who to direct the question to accordingly. Without further ado, committee, I turn it over to you. Any comments, questions for Minister and or his staff that are here with us today? Again, any comments, questions, concerns from committee with regard to the amendments to us today? Minister Moses?
Got a question. I'm questioning myself here. But really appreciate the leading up into this meeting, the correspondence that members had given myself and the staff to get a little bit more clarity on the bill itself, and just looking forward to the work that we can do with Nunavut and the work that committee is going to provide in terms of any questions that they may have. I'm hoping that the answers that we did provide in the correspondence were sufficient enough, and if there's any more clarity or detail that members need specific to any of the clauses and the questions that were provided to my office and to the staff, we'd be more than happy to answer them. But I really appreciate the back and forth leading up to this meeting. I think it really helped a lot of us out moving forward. So, thank you.
Thank you, Minister. First, I have Mr. Simpson.
Thank you. I know we'll have lots of questions, but everyone's gun shy, so I'll start it out here. And as you know, the committee sent some correspondence about a few of these clauses here, and I'll start with Clause 12. For those in the audience, Clause 12 states that an employer who has reason to believe that a worker in its employ has experienced exposure to toxic, noxious, or other hazardous substances that could possibly cause personal injury, disease, or death in the future must submit a written report. And I guess my concern about this is that it seems quite broad. If an employer has a reason to believe, so not even that an employer is sure, that an employee has been exposed to toxic, noxious, or other hazardous substances that could in the future lead to death. And I mean, if you just inhale some diesel fumes while you're filling a truck, that won't lead to death, but maybe if you do that every day, 6 hours a day for 10 years, that might lead to death. And so, could you clarify how this should be interpreted, or how WSEC interprets this? Thank you, Mr. Chair.
Thank you. Minister Moses.
Thank you, Mr. Chair, and as I mentioned, we did provide written response to committee members. I will just read that in for the record since this is a public meeting, and if we have any of the public watching, that they know what the answers that were given, and then I'll go to Kim if she wants to add anything further to this. So, Mr. Chair, the trigger is found in the words "reason to believe" at the beginning of this section. The employer is expected to know their workplace and the chemicals and substances that are used regularly or found in the workplace. The amendment contemplates the possibility that exposures may come from different sources and may not all be known at the time of the event. Thus, an employer would report the incident when the employer has reason to believe future harm can result from this type of exposure. One example is asbestos. This standard is a reasonable person test and essential rests on the circumstances of the incident or the event. This trigger is consistent with the internal responsibility system found in the Northwest Territories Workers' Safety and Compensation Systems. And Mr. Chair, if there's anything further that our acting Vice President would like to speak to, I'm more than happy to turn the floor over to her.
Thank you, Minister. Further to that, Ms. Riffle.
Okay. This covers the claims side of our organization. Under the Mine Health and Safety Act, WMIS 2015, and the federal legislation, any exposures or reason to believe that there has been exposure needs to be reported under that legislation already, and it's as soon as reasonably possible. So on the inspection and regulatory side, it's already part of the Safety Act. This is just adding that additional into the Workers' Compensation Act. Employers, you're right, are not always going to know. If we receive a claim from an injured worker who feels that they were exposed, our claims processing staff would contact that employer and indicate they have received a claim and gather the information and details in relation to that.
All right. Thank you. Further, Mr. Simpson.
So currently, if a worker becomes ill due to exposure to inhaling a toxic substance at some point in the past on a work site, they are ineligible for any compensation or benefits from the commission. Is that correct? Thank you.
Thank you. Ms. Riffle.
They are eligible to benefits for exposure. Oh, sorry.
No, that's correct. It just exchanges through me.
Okay, they are.
Over to you, Ms. Riffle.
They are eligible for benefits for exposure from the date that they're aware that they do have an industrial disease. So they would put in their claim either at the time of exposure, or what we're looking at now is a lot of hearing loss ones, and they'll put it in as a result of they've had numerous employers, and so they'll file a claim, and at that time, the claim is accepted after confirmation. Sorry.
Thank you. Anything further, Mr. Simpson?
Thank you. So what's the practical effect of this? Because from what I understand, claims can be, people can already can be eligible for benefits based on exposure, inhaling, toxic chemicals at a work site without this. So what is the practical benefit or the practical use of this clause? Thank you.
Thank you. Ms. Riffle.
For the injured worker, it's a huge benefit. They're putting in the claim when they have the exposure versus waiting for down the road till they happen to have something. They could work for numerous different employers, and not all their information is going to be documented. This way, it's on file, it's on record immediately upon the exposure.
Thank you. Further, Mr. Simpson?
Thank you. And so I guess from an employer standpoint, if I was an employer, I would be a little concerned about what I was supposed to be documenting. I mean, this carpet is 25 years old now, but they say carpet for 25 years releases chemicals, and maybe in 20 years we find out that causes cancer. I know that if you work in a popcorn factory, you can get popcorn lung. And I know there's been a case where someone enjoyed a bag of popcorn every day, and they ended up with popcorn lung. And so if there's popcorn in the break room, is that an exposure to toxic chemicals? This is such a broad clause that it captures anything. And my concern is that, we already burden employers with a lot of reporting, and this the care wasn't given to narrow this down in light of that. So does this provision necessarily need to be this broad? Thank you, Mr. Chair.
Thank you. First, I'll go to you, Minister Moses.
And then I'll get Kim to add a little bit more to this. When we look at making amendments to the Workers' Compensation Act, we want to do it in the best interest of our employees, as well as the safety and health of our employees. And if it is broad, we want to make sure that we're covering the whole gamut in terms of anybody that might be exposed, as you heard in some of the response and correspondence that we gave through the letter and the one that I just read on the record there. Really, it's for the safety and the health of our employees to make sure that they have the best options of reporting when they do have a reason to believe that they've been exposed. I will go to Kim a little bit more if she wants to add anything else.
Thank you. Ms. Revel.
Can I defer it?
Oh, sure.
Ms. Marion?
I was just going to say, this particular provision with the reason to believe is in the context of a lot of the existing processes that we have in place. So it's not the internal responsibility system. It's basically how, the practical part of it that you're talking about. This is basically how it's going to be triggered. A worker may put in a submission or a claim because they feel they've been exposed to something toxic, or an employer might be the one that will do the particular reporting. I think, too, it responds to some of the current law on this, different case law that has come out respecting these types of long-term injuries, and it's now part of our understanding of workplace safety. So it's to bring it into the modern work-life system, and it has been supported a lot by case law, and the leading case law has been on asbestos regarding this particular provision that will, take in these kinds of things. So I think the employers already are pretty much geared with our current system that we have in place, the internal responsibility system. It's not adding another layer or something special that they have to do. And certainly they can, employers in this case, and as they've done in the past, if they're not sure. We talk about the carpet, or, it's always the reasonable person test at the end of the day that'll be pretty, that will always stay in the back of the mind. We don't know, is it reasonable to assume 25 years from now this carpet's going to be some kind of toxic, be a cause of a toxic situation in the health of a worker? But it's basically reasonable person test, and asbestos has been sort of our leading cases on this particular, bringing this up to modern standards.
All right, thank you. Anything further, Mr. Simpson?
Yeah, just one last statement. And I understand that this is in the best interest of employees, and I think that there needs to be a balance, though, between best interest of employees and the capability of employers. We can't keep burdening people. I know people in Hay River who could have a couple of people working with them, journeymen, who, because of, these types of regulations, have decided it's easier to just work alone. And so there are economic effects to this. And, the witness mentioned case law. If there's case law that supports this, I think that's something that probably should be submitted to committee so that we can make these decisions. Because I don't want to, try and legislate, against things that have been proven in court to be, in the best interest of society. And so I think that when there's something so broad, it needs greater support than we've received on these 4 bullet points here. So I'll leave it at that, and I'll yield the floor, and I'm sure I'll have something to say In a minute. Thank you, Mr. Chair.
Okay, thank you. Take that as a comment. Comment noted. Next I have Mr. Testart.
Thank you, Mr. Chair. So Section 134 enables the Commission to inspect healthcare records, healthcare providers' records to verify that claimants have received services related to claims. My question is, was a privacy impact assessment done to ensure that there would be no issues conflicting with the Health Information Act or the Access to Information and Protection of Privacy Act? Thank you.
Thank you. Ms. Riffle or Ms. Marion?
I'm sorry, I didn't hear your question.
Thank
You wanted to know if there was,
Thank you. Clarification, Mr. Testart.
Was a privacy impact assessment done when contemplating this section, and what were the results of that? Thank you.
Thank you. Ms. Marion?
in this particular change was to enable health inspectors to verify that claimants have received services related to the claims. And it is certain that, you know, we took a look, we've looked at ATIP and what kinds of impact it has on ATIP. But whenever there's a conflict between, say, ATIP and the Act, we have provisions in the Act that allows us to override, because it's information that's directly on a claim. We can't go to, in this particular case, it wouldn't allow us to go to a provider and say, show us the records of, we'd have to have a name. And, you know, if the person had been one of their patients, and we'd have to have a reason to look at these records. So generally, it's an active claim. They've submitted information to us. And it's mainly a precautionary and audit kind of function that we want to achieve. The audit being that we have a protection, the protection fund, and we'd like to make sure that, because a lot of the costs involved in a claim and a claimant is the health provision that is given to a worker. So we would like the ability to be able to audit. And this is mainly to ensure the protection, the workers' protection fund is being efficiently supported. It's a big, the whole cost of claim regarding the health care provision is a big chunk of the cost that, claims cost that we have. So, yes, we've taken a look at ATIP, and we don't believe this is in violation of ATIP at all, and I think this is one of the reasons we wanted to bring this in, was to make it clear that we could verify or audit the records.
All right, thank you. Further, Mr. Testart?
Okay, thank you. So that would the same response be for Section 161, which is around the information sharing between the WSCC and the operational units.
Thank you. Ms. Marion?
Right now, we have, WSCC has several acts that it manages. Some acts, really, there's not symmetry sometimes between the acts, which would permit somebody in claims to talk to somebody in prevention regarding a particular claim file. It's kind of awkward because we're in the same building, we're on the same floor, and the people cannot share information that might be relevant to prevention or may be relevant to claims. So right now, it's kind of, silo, it's like a silo, and each one can't really mix. Sometimes it's possible, but generally the acts sometimes don't permit on the operational side, intercommunication on things. But certainly the healthcare records this does not involve healthcare records. So
All right,
strictly accident, what's happened. And I think maybe Kim might want to clarify
Okay.
the operational pieces of it.
Thank you. Ms. Riffle.
Okay. Clause number 35 is related to our internal auditors and fraud investigators going into, say, a medical supplier clinic and reviewing the records to ensure that our injured worker indeed did receive the care that we've been invoiced for. So it's externally focused. Clause number 36 is totally related to internal. It's the prevention team working with the claims team to provide more of a directed services approach to dealing with workplace injuries and focusing our regulatory in the areas that it needs to focus on.
All right, thank you. Further, Mr. Testart?
Yeah, thank you. So and I appreciate the policy rationale behind these changes. I'm more interested in the whether or not those impact assessments were done. And it sounds like you did take a look at ATIP and the relevant legislation that protects privacy. But did the commission consult with the Information and Privacy Commissioner in designing these two particular amendments? And if so, what feedback did the commissioner provide? Thank you.
Thank you. Ms. Riffle?
Yes, we did consult the Privacy Commissioner, and she did raise a few areas, and we did meet with her back in September of 2016 to discuss her concerns directly, and under the Workers' Compensation Act, after we had a chance to review that and the ATIP legislation, the Workers' Compensation Act did supersede the ATIP. One of the Privacy Commissioner's concern was the sharing medical information, so the medical side of the claim information, and that is not something that is shared. The medical stays with the claim side only, and any of the other information, sort of like mechanism of the injury or the employer, that is shared, can be shared with the prevention team.
All right, thank you. Anything further, Mr. Testart?
A few things, if I may, just on this thread. So how, what is the need for prevention service to receive that level of medical detail? Like I understand the audit, like if you're double checking audits, so there's that audit capacity, but will the changes in the Act allow prevention to access those records? And is there a real need for that to take place? Thank you.
Thank you. Ms. Riffle?
No. The prevention services team does not receive anything to do with the medical of a claimant or an injured worker. What information we would share with them under Clause 36 would be the employer, so that they can confirm that it's been filed under the Safety Act, that, the due diligence was done by the employer by filing the information that needs to be filed under the Safety Act, and where they can focus additional education or inspection and regulatory. So the information on the medical claim files, that is externally focused in that our prevention team does not get involved in that. That would be our fraud investigators and internal auditors would be going to the medical clinics and reviewing their records just to ensure that our workers received the services that we were billed for. It's a total audit function.
Right, thank you. Further, Mr. Testart?
And with Section 161 that kind of allows the disclosure of information, what safeguards are put into place to ensure that what you just explained to me is protected, right? So if that's the way it's supposed to operate, are there kind of hard safeguards built in that prevent someone in one division accessing information that another division has once we open it up by allowing information sharing between the operational units? So you see what I mean? Like if someone wants to go on, jump on the shared network and access a medical file, like what prevention is built into that, and what consequences would there be if that kind of oversharing happened? Thank you.
Thank you. Ms. Riffle?
Prevention Services team have no access to the claims management system. It is two totally separate systems. This information is relayed through, would be relayed through, mostly through emails, they're looking at establishing a system once we finalize this, so that, but the information that would go in there has nothing to do with the medical information. The only information that's going to be in there is that a worker was injured, the worker's name would be provided so that if they needed to talk to that injured worker, like I said, the mechanism of injury, location, that sort of information. Our claims management system, it's very limited access, and it's, even to the case management team, it's only accessible to those people involved in their portion of that case management.
Thank you. At this point, okay. At this point, I'm just going to ask Mr. Rutland to interject. Mr. Rutland.
I just one question to clarify. So your internal auditors and the fraud team, are they appointed as inspectors under the Act, under Section 104?
Thank you. Ms. Marion.
I could, I can't answer that question right now, but I could look at it. Under the Safety Act you're talking about? No.
The
Well,
Yeah. Well, they are.
thank you for clarification, Mr. Rutland.
the power to inspect medical records is given to an inspector, and then the Workers' Compensation Act provides that they can designate a member of its staff as an inspector. So I guess to what Mr. Testart was asking is, like, is someone on the prevention side, I designated an inspector, and is an internal auditor designated an inspector, and then would that power apply equally to either of them? I guess it's like a legal distinction?
Yeah, yes, yeah.
Thank you. Ms. Riffle.
It's my understanding that the inspectors are appointed under the Mine Health and Safety Act.
Yeah.
The Workers' Compensation Act would give the fraud investigator and the internal auditors an inspection designation is, but they're two totally different acts, and the inspector is used differently in the Safety Act than it is in the Workers' Compensation Act.
Thank you. Anything further, Mr. Rutland? Nothing further? Anything further, Mr. Testart?
Thank you for answering my questions on a technical area of statute. Just one final question. How often has fraud been a problem for the commission? I mean, it seems like certainly not extraordinary power, but significant change to be able to kind of go in and verify this. But has there been, a number of either high-profile fraud cases or many fraud cases over the years that require this change to deal with a problem? Like, are we correcting a problem, or is this a preventative measure? Thank you.
Thank you. Ms. Riffle.
Medical supplier fraud across the other jurisdictions is a significant issue. We haven't had the ability to go in and determine whether we are receiving all the services that we're paying for. But we do know, based on our counterparts across Canada, is that they're finding it is a significant issue.
Thank you. Nothing further from Mr. Testart. Next I have Mr. McNeely.
Thank you, Mr. Chair. I'm glad my previous colleague had mentioned that. We hear a lot of these accusations from the employees. Oh, I'm going to take you to the WSTV because I slipped, or whatever the case may be. And do you have a tracking system in place that after your investigation to a claimant submission, and you're checking with the health department, you're checking with the RCMP, or all whose stakeholders are involved, and this is deemed to be a fraudulent submission? Is there a tracking system for that you can go back annually and say that we had several hundred cases for the past 12 months? Thank you, Mr. Chair.
Thank you. Ms. Riffle.
No, not at this point in time. And our investigations mostly consist of the injured worker files the claim, the claim staff will contact the employer, will contact the witnesses, and based on the information that they gather, they will accept the claim or deny the claim. If the claim's denied, that worker has the right to go to request a review of that decision. But as far as investigating, we do not have a system in place. And as far as a fraud investigator go, they're generally, I can think maybe 2 in the last 3 or 4 years that we've ceased compensation payment on, but we've never laid charges or anything like that.
Right, thank you. Further, Mr. McNeely?
Yeah, thank you, Mr. Chair. I just wondered if there was a preliminary assessment to see if on the validity of the claim, if there is that assessment prior to taking it seriously. So maybe if there is none, there may be a policy should be developed to reflect that and determine whether the case is legitimate or we're just wasting our time. And my other, that's just a comment. But my question is, has it been assured that the definition of impairment in Bill 25 is not in conflict with definition of impairment in other acts? As you know, we just went through the cannabis legislation, and impairment is within that act. Is this one consistent with other acts in reference to the wording of impairment? Thank you, Mr. Chair.
Thank you. Previous comment was noted, and Ms. Marion, over to you.
Mr. Chair, when these amendments were made, it was made in light of the Cannabis Act as well, and the need to change how we define the impairment. And so, yes, to answer your question, it has been reviewed against the new legislation. It has been reviewed against previous legislation. So the drafters, this is one of the first things they would look at to see that there was consistency in how a certain terminology or word is used in the context of how we use it, but also in the context used in other legislation. So it's pretty common.
Right, thank you. Further, Mr. McNeely?
None at this time. I'll have.
Nothing further. Next, I have Mr. Nakamayak.
Thank you, Mr. Chair. Thanks for your clarification on this. I'm just looking at Clause 15 on removing the word primary to allow direct change in healthcare providers. It's not really, I think it's more of curiosity. I'm wondering what, looking at a bunch of things like, the costs of NWT healthcare system, to cost to employers and their insurance. Obviously, working for a number of employers around the territory in some construction areas where sometimes they're operating heavy equipment and they're working around hazardous areas. I'm just wondering what maybe a couple of things. What are the positives to this here for workers' compensation and ultimately the care for employees who get injured on the job, who seek rehabilitation for the types of injuries that they have, and sometimes they may have to travel out of the territory, and without costing the government or WSCC too much money and all of this. So what are the benefits of this? Like just to hear a few different scenarios from you would be good actually to kind of learn this more so that we can help refine it better, so that we better care for individuals. Thank you, Mr. Chair.
Thank you. Ms. Rivel?
One of our concerns was with the changing environment in the healthcare provision, it's very difficult for an injured worker to see the same healthcare provider each time. So that was why the word primary was taken out of there. So it'd give them the opportunity not to have to try and wait or see that same physician or medical practitioner or nurse in charge. Those individuals tend to change fairly quickly. And so one of our, that was the reason why we had suggested the word primary come out of there and keep it broader so that healthcare provider was used.
Great, thank you. Further, Mr. Nakamayak?
Yeah, thank you for that clarification. I'm just wondering too, like, you know, they're introducing telehealth and things like that where you can actually work remotely from communities. Myself, coming from a small community, I was wondering, looking at, you know, possible benefits like that to individuals who may not want to travel, so that they can actually sit in front of a computer screen or a TV screen and get some advice from a doctor or a physician. I'm just wondering if things like this would apply and how would it benefit Northerners. Thank you, Mr. Chair.
Thank you. Ms. Rivel?
Okay, using telehealth, we're not at that stage yet. We are working with our one of our service providers in Voc Rehab and in Physio to come up with a way that we can do that. At this time, we're not there yet. So as far as telehealth from that perspective, no. Our injured workers currently receive those services from wherever they would need to travel to in order to receive them.
Thank you. Further, Mr. Nakamayak?
Thank you for that. You know, just looking ahead, you know, as we plan and as we go into the next assembly and you look at bills like this, it's, you know, it's always good to keep the money in the Northwest, in the territory, rather than sending individuals out of territory, sometimes other provinces, to seek the health that they need. It'd be nice if we could actually work towards that so that we can build capacity in the territory as well, too. Thank you, Mr. Chair.
Thank you. Take that as a comment. Comment noted. Next I have Mr. Testart.
Okay. Thank you, Mr. Chair. So I have this is probably best addressed to the minister, but what has the minister's involvement been with his counterpart in the government of Nunavut on bringing forward this bill? I'd just like to get a better understanding, because this is a very special relationship we have with Nunavut in regards to the WSCC and various other, shall we call them, trans-territorial commissions, agencies, corporations. So if we could just get a better understanding of that. Thank you.
Thank you. Minister Moses?
Thank you, Mr. Chair, and I did try to reach out to the minister just to get an update on where they were. As I mentioned, they did receive their second reading of the bill on October 25th, 2018. I do believe it was held up due to more priority legislation with the government of Nunavut. We will be obviously working with them. I have been through the process with NEBS on this on cross-jurisdictional legislation that's going to impact both the government of the Northwest Territories and government of Nunavut. So obviously, I have been taking notes here that comments that have been brought up today, I will be sharing with the minister, and I'm sure the clerk's office and committee will be sharing this with their counterparts in Nunavut as well. I think there's a responsibility on both sides from committee, but myself as minister to ensure this gets put forward. They have gone through second reading, so I'll get an update to where they are in terms of how they're going to be moving on this piece of legislation.
Thank you. Further, Mr. Testart?
Yes. Thank you. Thank you, Mr. Chair. Thank you, Mr. Minister. I think that this, it's the problem I foresee if it comes to pass is let's say this committee amends the bill, with your consent, of course. But let's say something happens to change the bill. I would imagine then that Nunavut would be more or less, the government of Nunavut or the Legislative Assembly would be more or less compelled to change that bill. However, if they do not, if we have a difference of viewpoints on the committee, then we're left in a situation where the Commission's statutes and regulations work one way in the Northwest Territories for Northwest Territories circumstances, and a completely different way in Nunavut. And for one example, the limitation period that's proposed to be changed from 3 to 2 years. If, let's say that amendment, or that carried here, or if that was deleted here, and it was stated 3, but it changed in Nunavut to 2, then you have an separate appeals process, and it's going to be very cumbersome for the WSCC to move forward. So I wonder if you've contemplated, if anyone of your witnesses, because I'm sure the Commission deals in this environment more than you do, but certainly have you contemplated this, and do you have a plan in case that should be the wish of this committee or our sister committee in Nunavut. Thank you.
Thank you. To that, Minister?
Yeah, thank you, Mr. Chair. I think any amendments to any bills that, as I mentioned, that's going to impact to us and the government in Nunavut, we'll have to take into serious consideration in terms of how it's going to impact us working together. I do believe we have been working closely, the drafters, obviously, and as I mentioned when I was in the process with NEBS, all the amendments going back and forth and sharing it with the committee, with Government of Nunavut, and, well, the drafters as well, was a very lengthy process. We had to come to agreement, and maybe I'll ask Ms. Miriam if she wants to add anything further, but definitely taking all that into consideration.
Thank you. Further, Ms. Marion?
Mr. Chair, so one of the things that we try to do a lot is harmonization of our act, our legislation, so it mirrors the Nunavut legislation. Nunavut legislation try to do that with us. Sometimes there is, Nunavut might be here and we're over there, or they're ahead of us, and so we're always catching up and always in communication. A good example, a recent example, is the cannabis legislation and how we were going to do this in Nunavut and how's it going to happen here. And there was a piece about smoking within 3 meters of a building, and our legislation said 9 meters. So it's actually an amendment situation where we're going to correct these inconsistencies in Nunavut and what we have, but it's mainly an area of catch-up, and in this case, both are, of course, are being looked at pretty much at the same time. They're going to be looking at this as you are doing now in March. So if anything comes up today, certainly we will be in conversation with the drafters in Nunavut and see how things go there.
Right, thank you. Anything further, Mr. Testart?
Are there any kind of operational challenges if things, so when you do find yourself, the commission finds itself in this position where there's two different things, is it substantial operational challenges, or are you experienced enough with both pieces of legislation that it doesn't cause many problems? Like you don't have, for example, an inspector who's mixing up, is this Nunavut or is this NWT? Is there people usually fairly consistent in the rules they're working with? Thank you.
Thank you, Ms. Riffle.
We do have an office in Iqaluit with our safety professionals, our case management, and our employer services groups. So they know their legislation, and there are some inconsistencies based on some of the other acts that are applicable in Nunavut. So we've managed them to date, and in the event that, we on occasion have to send someone from Yellowknife over to Nunavut and Nunavut comes over here, then those things are part of that sort of like that quick orientation that they do before we would send an inspector out. So.
Okay, thank you. Anything further, Mr. Testart?
No, that's satisfactory. Thank you, Mr. Chair.
Thank you. Next I have Mr. Simpson.
Thank you, and I apologize if this has been covered. I've been flipping through papers here, but Clause 33 is the clause that allows WSCC to enter into agreements with another jurisdiction. It's a repeal and replace of Section 95 in the current Act that gives the Commission power to make agreements with a public body in another jurisdiction responsible for workers' safety or compensation. So what the Commission is suggesting it be replaced with is a much broader clause allowing the Commission to enter into an agreement with the Government of Canada, a government of a province or territory of Canada, an Aboriginal government, or with a ministry, board, commission, or agency of such a government. And so it is being expanded from other worker safety and compensation bodies to any sort of government body in Canada, really. And when the committee asked about this, we asked why were the existing provisions inadequate to meet WSCC's needs, and we were told that the provisions do not allow the WSCC to enter into information sharing agreements such as MOUs with CRA. And if that's the case, why isn't CRA enumerated here, or perhaps the Government of Canada. Why do we have all of these other bodies? Could I get some explanation on that? Thank you, Mr. Chair.
Thank you. Ms. Marion.
We are the only jurisdiction in Canada that does not have the capacity to enter into agreements outside of the four that in the previous legislation. And it's interesting because many of our workers end up living in other jurisdictions. So we're constantly dealing, say, with a worker that may have been injured in Nunavut, for instance, who lives in Newfoundland, and we may want to get verification of income and all the rest of it from the CRA, but we can't. We don't have an agreement. But CRA has an agreement with us where we can provide them with information, but it's not, the reverse isn't possible. So that's an example. Now, CRA, is pretty obvious. It's income, information, payroll, information. Again, to ensure that our acts are acting in the best interest of the employers and in the best interest of the workers. It's again to prevent some of that fraud that the former member was talking about. If an employee or a worker is on other income, other monies are coming in and we're not aware of it, we don't have an MOU, so CRA won't provide us that information. So it's not an extraordinary section or power. It is in existence in Canada among all the jurisdictions, and we're trying to be on the same plane so that we can ask information from Newfoundland, from other provinces, Manitoba, Alberta, and get that information that would ensure that our claims are being they're not in fraud, and we're doing what we need to do.
Right. Thank you. Further, Mr. Simpson?
Thank you. And so I understand that, and it sounds like you need not just information from the CRA, but information from, say, the province of Manitoba for, maybe can you explain what information you get from the province of Manitoba? Would there be like income assistance benefits someone might be getting? What would they be getting from the province of Manitoba that CRA wouldn't know about? Thank you, Mr. Chair.
Thank you. Ms. Marion?
I think I may defer this to Kim because she knows more about some of the claims from outside jurisdictions, but.
Okay, thank you. Ms. Rivel?
I just want to start by apologizing. The CRA was just one of the many examples that we were using, and the way it's worded in here, that's not exactly clear. From province of Manitoba, I'm trying to think of what we would be going into an agreement, an MOU with them would be. Can I use a different example? Like motor vehicles. I know motor vehicles across Canada and the WSCC have MOUs in place so that if we're trying to find someone, if we're trying to validate some information on an injured worker, that they utilize that as a tool as part of the investigation process. I can't exactly think of something where we would deal with government of Manitoba, but.
Well, one of them might
Thank
be
you.
healthcare.
Ms. Marion?
Sorry. One area may be their healthcare services. If they're providing services to a worker and we're providing services to that worker, we'd want to know if with an MOU, specific information could be set out so that we might be able to find out. So there's no double dipping or those areas.
Okay, thank you. Further, Mr. Simpson?
Thank you very much. And so it's basically for investigative purposes is what it sounds like. What about an Aboriginal government? Why would there need to be an agreement with an Aboriginal government? Thank you, Mr. Chair.
Thank you. Ms. I'll go back to Mr. Simpson.
Thank you. You know what I can do?
One moment, Mr. Simpson.
Yeah, I mean, this is a pretty broad power that the WSCC is asking for, and I think that I'd like to know if it could be narrowed down to an enumerated list, perhaps, something a little more specific, because I noticed that when legislation comes before us, a lot of entities say, oh, we need a power to do this, and then they request a power to do that, and then everything else under the sun. And this seems to be an example of that. So if the minister wouldn't mind providing the committee with some substantiation for this, because this is a broad power, and I don't like to just hand out this sort of broad power to arm's length bodies, let alone, or, you know, any government body. So I'd appreciate that. And so I don't need an answer right now about what they would do with an Aboriginal government, but I'd like that substantiation.
Okay, thank you, Minister. That's a bit of a commitment there. Minister Moses.
Yeah, we will take a look at it. As mentioned, there's been a lot of really good comments around the table tonight. I will also make a commitment to reaching out to my counterpart in Nunavut and bring up some of these concerns and seeing what they've heard as well. This one here, I think it's something that is needed. It's been said that we're the only jurisdiction that doesn't have this ability, and when we have employees that have worked here in the north or even in Nunavut and go back to living in another province, we got to make sure that they're not double dipping. They're not getting money from us. They're not getting money from, let's say, another jurisdiction. In terms of the Indigenous governments, there could be also payroll income that they might be getting, where we might not even know if they're back to work, and yet we're still continuing to provide a disability payment. So there's a few things that really need to be taken in consideration, and I think this clause here specifically allows us to enter those MOUs so that we can make sure that past employees of the GNWT who may have experienced a workplace injury are not double dipping in terms of their claims. So, but we can provide a little bit more information for the member, and I'm sure that we will be getting a letter from committee in terms of more clarity on some of these things as well. And as I mentioned, Mr. Chair, I will be reaching out to my counterpart in Nunavut and bringing up some of these preliminary discussions on what we've heard here tonight, but also anything that they've heard. And I know that the clerk staff and the drafters will be working closely together as well. Thank you.
Okay, thank you. Further, Mr. Simpson?
Yeah, I'd like to see this and the previous provision I was talking about pared down quite a bit, and I'd like to see the commission just requesting the powers that they need, not all the powers under the sun. And I know that other jurisdictions have this, and I'm not sure if it's verbatim, but I don't like to bow down to the wisdom of politicians in other jurisdictions. You know, we're legislating for the Northwest Territories, and you know, we have specific needs here. So just a comment, I appreciate everything that the minister just said. Thank you, Mr. Chair. Nothing further.
Thank you. Points are noted. Further to that, Minister Moses.
Yeah, we can look at what other jurisdictions have done in terms of signing MOUs across the country, and look at what we can do that adjust it to what we need to do here in the Northwest Territories, but we'll look at what other jurisdictions are doing for sure. Yeah.
Thank you. Next I have Mr. McNeely.
Thank you, Mr. Chair. As you know, the Human Rights Act is undergoing changes as well, and that was taken on the road. And I'm just wondering if Bill 25 aligns with the changes or the amendments to the Human Rights Act. Have you reviewed the Human Rights Act and the amendments to that act and aligned it with Bill 25? Thank you, Mr. Chair.
Thank you. Ms. Riffle.
Okay. Some of the changes that we have in Bill 25 are a result of human rights legislation, or human rights, legislation. We've had a couple of the decisions that we've made at the Worker Safety and Compensation Commission go through the human rights, and as a result of those, that's where the EI item, where it indicated that needs to be part of considered as part of a worker's salary in order for the wage calculations. So yes, we are aware of the changes, and we have been working and some of the changes in this bill are a result of that.
Thank you. Further, Mr. McNeely.
Okay, thank you. Thank you for that reply. It looks like you had reviewed the changes to the, or looked at the Human Rights Act changes or amendments. Thanks.
Nothing further? Anything further from committee? Seeing nothing further from committee, Minister Moses, I'll turn it over to you if you have any closing comments.
No, like I said, Mr. Chair, really appreciate the the thorough work that committee's done. Appreciate the correspondence leading up to tonight's hearing and working with yourself and your staff to make this go as, I wouldn't say as easy as possible, but making sure that we're getting things addressed ahead of time. And as I mentioned, I have made some commitments here this evening, and I will be reaching out to my counterpart in Nunavut to give them a little update and see where they are as well. Really appreciate some of the suggestions this evening, and we'll be taking that back and look forward to the report after the committee takes it on the road. I know you guys are going to have a pretty busy schedule here next little while, and this one's very important, and I think it's great that we're going to be doing a cross-jurisdictional piece of legislation again. Thank you.
Thank you, Minister. Thank you to you and your staff, and we look forward to continuing to work with you as we move forward. With that, we'll end this portion of the public hearing. And does committee agree that now we can open up the floor for any comments from the public? Okay, thank you. Minister, you and your staff can depart. Okay. Thank you. All right, committee. We have one member of the public that is going to present before us is Mr. Darrell Delaney with Boss Consulting Limited. Mr. Delaney, it's always good to see former members of the House back in the House, or at least in the committee rooms. So with that, we'll turn it over to you to officially introduce yourself and share your comments for the record. Thank you.
Okay, thank you, Mr. Chair, and thank you, committee members. My name is Darrell Delaney. I'm representing my consulting company, Boss Consulting. And as the chair indicated, I did play a bit of a role here a few years ago in the 17th Legislative Assembly. It's like deja vu coming back in this room, except from a different point of view. So thank you very much for allowing me to speak on behalf of the public with respect to the Bill 25. First and foremost, I have not made a formal presentation, but there will be an observation of one or two parts of the Act here. But before I do so, I want to just thank the minister and his team. I went through the Act and the changes. They did a very good job on doing a lot of cleanup of the nomenclature, a lot of the definitions, and some of those were actually noted here earlier today by the committee. That being said, my background post-politics has been in the area of health and safety for a number of years, as an auditor of health and safety, as a trainer of health and safety, and as a policy designer under health and safety. So I'm able to bring that experience, not just from working in NWT, but also working in Nunavut as well. So I've had the pleasure of working in both jurisdictions, being in almost every community and teaching employers and workers in those jurisdictions. So when I'm speaking to the committee, I'm speaking with the pretense of always trying to make sure that whatever law we do in health and safety, we always have to be cognizant of our end user. That end user is the worker, and that end user is the employer. And we have to make it as simple as possible. So with that, I just have a notation that I want to bring to the committee's attention and also to the minister and his team's attention, is that Section 17 and Section 18 of the Act, where there's a duty to report. There's a reporting of Section 17 with respect to a worker who experiences any of the following events arising out of and during the course of the worker's employment shall report the event and to the worker's employer and to the commission as soon as it's practical. And it has Section A, which includes a personal injury or disease, and Section B, which is I have a bit of a concern, and that's the exposure to toxic, noxious, or other hazardous substances that could possibly cause personal injury, disease, or death in the future. This same section is somewhat repeated in Section 18 under the duty to report of the employer, again mirroring both Section 17 and 18 conclusively. The reason I'm drawing this to your attention is that when you look at Section 17B, when it talks about the exposure to a toxic, noxious, or hazardous substance that could possibly cause personal injury, disease, or death in the future, this act is actually singling out one specific accident, one specific incident. And in doing so, it actually makes an exception to the rule, and it kind of goes against the grains of the NWT and Nunavut Health and Safety Act itself. Embedded in the NWT Health and Safety Act is provisions under the terms dangerous occurrence. Now, dangerous occurrence, it's actually in Section 9.1 of the Act, and it's also found in Section 16 of the Health and Safety Act of the Mine, they call the Mine Health and Safety Act. Whereas a dangerous occurrence is described as an employer shall, as soon as reasonably possible, give notice to the Chief Safety Officer of a dangerous occurrence that takes place at a work site, whether or not a worker sustains injury. The definition of dangerous occurrence is very heavily prescribed in the Act, which tells the duties to report. It lists a number of different injuries or accidents in the workplace where the onus on the employer is to report whether or not a worker sustains injury. When I look at Section 17 and Section 18, again, as I say, it's singling out a specific accident or a specific incident, which really, in its context, really should be considered one of those dangerous occurrences. It's kind of making an exception to the Health and Safety Act. And as I said earlier, as I kind of did a preamble, is that we need to be, as legislators, and I was one of you many years ago, is that whatever we do, we need to make it as simple as possible for the end user. So we're not having to go into various forms of legislation to understand when do I have to report. So again, as a strong suggestion, and also to the Minister's office, as well as to Minister Hicks and Nunavut, I would strongly advise the committee to consider removing Section 17B and 18B and including that in due time or due course within dangerous occurrence clauses of the Health Act itself, thereby making duty to report by an employer or also worker in one act and not two. And actually, other than that, Mr. Chair and committee members, I'm very pleased with the changes, and I'll open myself to any questions if any of the committees have questions for me. Thank you, Mr. Chair.
Thank you, Mr. Delaney. Committee, any comments, questions, concerns for Mr. Delaney? Mr. Simpson.
Thank you, and thank you for that. And I'm well aware that you're in the safety business because I took my supervisor safety training from you a little while back. So your contention is that what is captured in Clause 11, which would be repealing and replacing Section 17, is captured under dangerous occurrence in the Safety Act. And you mentioned that a dangerous occurrence has to be reported whether or not an injury was sustained. Now, does that cover the idea that 17B says or states is that an injury could occur in the future? Because an injury did not occur, but the dangerous occurrence doesn't sound like it requires, or it doesn't sound like it contemplates that. So can you comment on that? Thank you, Mr. Chair.
Thank you. Mr. Delaney.
Thank you, Mr. Chair, and the member is correct, and the member did pass his course. Congratulations. Prize student.
It'd be funny if you outed him if you didn't.
Mr. Chair, and to the member here, it's a very good question. The dangerous occurrence, again, does describe various incidents in which there is an onus to report. The current dangerous occurrence definitions does not include exposure to toxic, noxious, or hazardous substance that could possibly cause injury, death, or disease in the future. It does reference reporting if there has actually been a spill. It does not denote how much of that spill, but it talks about a spill of a toxic substance. So there is also provision there that actually references in a sublime way very similar language to what you see here in 17B and 18B. So again, Mr. Chair, what I'm trying to do in my recommendations is that trying to keep the simplicity of information to the general public, where to find duty to report, and again, there's provisions under the Act, the Health and Safety Act, which under dangerous occurrence, it's already done. When I see it written in this format here in Bill 25, now there's just another place for employers and workers that have to go find and look up and go, what else, what are my other duties that I have to do for reporting? My recommendation is that this should be consolidated into dangerous occurrence section in the Health Act itself. Thank you, Mr. Chair.
Thank you. Further, Mr. Simpson?
Thank you, and I think that's a salient point. You know, it's been a while since we looked at this legislation, and today, when I was going through my notes and I saw that provision, I thought, are we looking at the Safety Act or are we looking at the WSEC Act? Because it is very reminiscent of the Safety Act. So I appreciate that, and I think we'll look further into this. And yeah, that's it. Thank you very much for your comments. I appreciate it.
Thank you. Comment noted. Next I have Mr. McNeely.
Thank you, Mr. Chair, and thanks for your presentation there, Daryl. My question is similar to what some of the questions we asked earlier. Would you be satisfied if both acts were worded the same? Thank you, Mr. Chair.
Thank you. Mr. Delaney.
Thank you, Mr. Chair. To the member's question, that's a good question. If they were cross-referenced, at least then there's some duplication in terms of accessibility to the public, but it also provides clarity to the public, so that might not be a bad idea to explore. My concern is to have a norm which you'd find in the Health and Safety Act, which is quite a daunting act in itself. It's over 500 pages long, but I'm always concerned about the end user in terms of having to know when to report, how to report, and what to report. So if it is the decision of the committee to cross-reference this information in both acts so that the message is consistent, at least then the reporting aspect for the consumer, the employer, the worker, is also consistent. Thank you, Mr. Chair.
Thank you. Further, Mr. McNeely?
Nothing further, just closing comments. Yes, I look forward to comparing the two. Thank you.
Thank you. Anything further from Mr. Delaney? Comments, questions? Mr. Testart?
Thank you, Mr. Chair, and thank you for your presentation, Mr. Delaney. Are you aware of any other safety legislation that has a duty to report, or is it, to your knowledge and with your experience, is it all kind of contained within the Health and Safety Act? Because there's also the Safety Act. You know, we have inspectors under the Explosive Use Act, so there are a number of occupations that have safety concerns, but are the reporting requirements, to your knowledge, mostly contained in the Health and Safety Act? Thank you.
Thank you. Mr. Delaney?
Thank you, Mr. Chair. And to the member's question, I wish I could answer that question with a high degree of authority. My expertise is mostly in the Health and Safety Act, and I have some provision knowledge in other acts itself. To the question, the Mine Health and Safety Act, as well as the NWTNU Safety Act, are fairly close by nature, and they do have duties to report in there that are similar by nature, albeit a little different in the Mine Act. There are other reporting aspects in other acts, but when it comes to the reporting of injury or accidents, your Health and Safety Act is by far, by definition, in the practical sense, your go-to document in terms of reporting. There are other reporting requirements in the Act, but when it comes to incidents that are defined, as I said, under the term dangerous occurrence, it is actually very prescriptive. And because we are actually in Bill 25, we're singling out a very specific accident. We're talking about exposure. And because we're singling out this particular Section B, we're giving it, I think, unfair due consideration. And I think we're kind of making this a little bit of confusion for the consumer. And having it in one singular act, or as recommended, cross-referencing that, I'm just trying to bring to the attention to the committee that we should always be considering the simplicity of our acts and the ease of what do I report and when do I report and who do I report to. Thank you, Mr. Chair.
Thank you. Further, Mr. Testart?
Yeah, that's a really excellent point, and sometimes governments need to be reminded of that. So in your professional experience, since you've been involved in training employers and workers as well, what kind of feedback do you get from people on the complexity of the regulatory environment? And what I mean is I'm assuming this comes from both your places, both your own personal experience and based on your experiences training and talking with employers around this. So have they expressed kind of a desire to see things streamlined a bit more, or put into the same place? Is this a concern you've heard from your clientele? Thank you.
Thank you. Mr. Delaney?
Okay, thank you, Mr. Chair. To the member's question, it's a bit of a broad question, maybe a little bit broader than the scope of this bill here. To answer his question as truthfully as I can, the health and safety in general is a very complex institution to train and for the employer and worker to understand. I know that the WSEC and their powers that be have tried to make it as easy as they can. They provided many tools. There's lots of communication out there, and I think they do a fairly good job in doing so. That being said, it is very complex in terms of reporting, how to do things. So again, the comments from the community at large, workers, employers, is that anytime that we're able to make it simpler and easier for them in terms of understanding what to do and who to do it with or for, I think that's something that we should always be cognizant of. So yes, to the member's question, the general public is looking for simplicity rather than complexity.
Thank you. Anything further, Mr. Testart?
No, Mr. Chair. Thank you, Mr. Delaney.
Okay. Thank you. Anything further from committee for Mr. Delaney? Seeing nothing further, if there's no other presenters, Mr. Delaney, you can be excused. Thank you for your comments. Much appreciated. Committee, as there are no other presentations from the public, does committee agree that this public hearing is concluded on Bill 25, an act to amend the Workers' Compensation Act?
Yes.
Agreed. Thank you. This portion of our meeting will be concluded, and I'll just ask committee members if they can remain for a brief wrap-up discussion.